Hello class, my name is Carlos Garcia and today I will be presenting with my group conformed by Leon, Jimena, Joaquin, Santiago, Anisha and Jorge a labor law related topic which is the EU Directive 2019/1152. This is the table of contents we will be focusing on, starting with a brief introduction till the impact the directive has been causing since implementation. Now let's jump to the introduction. Directive 2019/1152, known as Transparent and Predictable Working Conditions Directive, is a significant piece of legislation enacted by the European Union in order to address the challenges arising from evolving work arrangements in today's labor market. The directive aims to enhance workplace fairness and worker protection by promoting transparency and predictability in employment conditions. It also represents a significant step in harmonizing labor standards across the EU and ensuring that all workers, regardless of their employment arrangements, enjoy transparent and predictable and also dignified working conditions. The gig economy is a labor market characterized by short-term, flexible work arrangements in which individuals, often referred to as gig workers or independent contractors, perform tasks or provide services on a project-by-project basis, typically through digital platforms. Gig workers often lack traditional employee benefits, such as job security or other social benefits, and they are paid for the specific task or gigs they complete. This creates many challenges, such as job insecurity. As a result, the European Union has devoted significant efforts in solving the employment preoccupations of its main actors, mainly through this directive.
To begin with, we'll be going over the scope and purpose of this directive. The scope, objective, and purpose of this directive are codified in Article 1 of the directive, and it lays out the following functions for it. So the main purpose is, of course, to improve working conditions by promoting more transparent and predictable employment, but also ensuring that the labor market stays adaptable. Further, it also aims to enhance work-life balance. How does it do this? This directive regulates things like working time, rest periods, employees' right to request flexible working arrangements, and a lot more. This directive also recognizes and protects the rights of more vulnerable types of employees, such as part-time employees or on-demand workers, and makes sure that they are also given access to the same rights and are not exploited. And of course, similar to past directives that we have seen in class as well, and in general, the directives surrounding the labor market, we've seen that they protect the labor rights, they set clear standards for employers to follow, and they establish labor standards, and overall, it reinforces rights available to workers. Then we move forward to the scope, which is who does this directive apply to? Of course, this directive is applicable to every single worker in the European Union with an employment contract or an employment relationship. However, there are some interesting applicability rules for member states. For example, member states can choose not to apply these rules to workers with an employment relationship in which their actual working time is equal to or less than an average of roughly 3 hours per week in a reference period of 4 consecutive weeks. So someone who is very, very part-time, essentially, and not a frequent worker, member states it's up to them to decide if they want to apply it or not. As for law enforcement services, such as investigators, judges, police, the provisions of Chapter 3, which cover minimum requirements relating to working conditions, are not applicable. And there are also some articles that are not applicable to seafarers. So overall, everyone with an employment contract, it applies to, but there are certain limitations depending on what your specific line of work is.
Thank you so much, Anisha. Now we're going to take a look at the key provisions and rights of Directive 2019/1152. So the first of them is the probatory periods. So under this directive, probatory periods for employees cannot, except in exceptional circumstances, exceed 6 months. So what are these exceptional circumstances? So they can only exceed 6 months only when justified by the nature of the employment, such as for managerial or executive positions or public service posts, or where in the interests of the worker, such as in the context of specific measures promoting permanent employment, in particular for young workers. The second key provision of the directive is the information on essential aspects of work. Employees must be provided with essential information about the contractual relationship in writing and within the first 2 months. This essential information is basically information about the parties, about the workplace, job position, the salary, etc. This comes from principle number 7 of the European Pillar of Social Rights, which provides that workers have the rights to be informed in writing at the start of their employment about the rights and obligations resulting from the employment relationship, including any probatory period. That prior to any dismissal, they are entitled to be informed of the reasons and given a reasonable period of notice, and that they have the right to access to effective and impartial dispute resolution, and in the case of unjustified dismissal, they have a right to redress, including an adequate compensation. The third of the key provision on rights of Directive 2019-1152 is the prevention of abuse of zero-hour contract. This directive aims to curb the abuse of zero-hour contract or on-call work arrangements. But you may wonder how. So the directive asks directly to member states which allow such contracts to deploy measures such as limitations to the use and duration of such contracts, of a reputable presumption of the existence of an employment contract or employment relationship with guaranteed amount of paid hours based on hours worked in a preceding reference period. Also, the directive specifies that it applies to contracts regardless of the number of hours they actually work.
Following the key provisions explained by Jorge, we have that of parallel work. Found in Article 9, it poses that member states must ensure that employers neither prohibit a worker from taking another job nor subject them to adverse treatment for doing so. Say you work at a marketing place from 9 to 5, but you're short on cash. So you decide to take a night shift at a pizza place. Your boss finds out and fires you. Well, thanks to this article, he can't. However, MS can lay down conditions for incompatibility restrictions on the basis of health and safety, confidentiality, integrity of public service, or avoidance of conflicts of interest. Lastly, we have cost zero training, or Article 13, which lays down that MS must ensure that where employers are required either by a union, national law, or collective agreement to provide training to a worker which is necessary for their job, it shall be free of cost, shall count as working time, and if possible, be during working hours. Imagine you're a lifeguard at a club pool, but extra certification is needed for you to be able to work. Your boss calls you in and tells you to pay a €500 class that you must take every Sunday until you're done, on your free days. Guess what? That's not allowed anymore. These provisions are designed to enhance transparency and of employment relationships, protect the rights of workers, and promote fair and predictable working conditions within the European Union. Now, let's hear Leon explain how to implement it.
Now we will examine the implementation and transposition process provided in the directive. Member states are required to implement the provisions of this directive into their national legislation. But what guidelines does the directive give or impose to the member states? Well, first of all, each European member state has a transposition period. In this case, it was published on the official journal on June 2019, and Article 21 stated that member states shall take the necessary measures to implement it by 1st of August of 2022. That is around 3 years. Another important measure imposed to member states is the obligation to communicate to the Commission the text of the main measures of national law which they adopt in the field covered by this directive. Moreover, the most relevant step that member states must comply with is the adequate judicial and administrative protection to ensure the effective involvement of the social partners and against any adverse treatment as a reaction to an attempt to exercise rights provided for under this directive. Finally, to guarantee the results of the directive, member states should avoid imposing administrative, financial, and legal constraints in a way which would hold back the creation and development of micro, small, and medium-sized companies. Member states are therefore invited to assess the impact of their Transposition Act on small and medium-sized enterprises in order to ensure that they are not disproportionately affected.
Thank you, Leon. Now we are going to talk about the enforcement of this directive. By the 1st of August of 2022, all EU members must have transposed the directive on transparent and predictable working conditions into their legislation. Although member states may decide to apply some limited exceptions based on objective circumstances, until this moment, only Germany, Italy, Slovakia, Romania, Netherlands, Bulgaria, Belgium, and Spain have correctly transposed the directive. Nevertheless, it is important to remark that directives have what is called an indirect effect, meaning that although the directive hasn't yet been transposed, the provisions can be enforced by a court. That being said, now let's move on to how this directive is enforced specifically. Well, unlike the 1991 directive, which received little attention in practice as it did not provide for any sanction, this new directive requires member states to establish effective penalties for any breach of the requirements. Member states shall lay down the rules and penalties applicable to infringement of national provisions adopted by this directive, which can be financial penalties, like German employers, which can be punished with fines up to 2,000 euros. However, this is not necessarily a requirement. Lastly, this directive provides monitoring mechanisms. In this case, the European Commission plays a supervisory role in ensuring that member states properly transpose and enforce EU directives. Specifically, Article 23 of the directive states that by the 1st of August of 2027, the Commission shall, after consultation with the member states, review the implementation of this directive and propose, where appropriate, legislative amendments.
Let us now talk about the impact of the directive and how effective it is on solving some of the issues behind the gig economy. Let's first focus on the positive impacts. The directive will provide a more extensive and updated labor rights and protection to the 182 million workers in the European Union. EU employers now must timely provide their employees with information concerning their essential working conditions. Otherwise, they run the risk of being fined in many EU member states, as previously mentioned. Some negative aspects, or perhaps impracticalities of the directive, is that, for example, there are already different loopholes or approaches companies have found in this area, such as not fully implementing and documenting all required information in the employment contract itself, but rather in a secondary documentation letter that preserves the employer's right to amend employment condition. Another negative aspect is that the information requirements apply primarily to new hires, not existing ones. Another negative aspect is that as a result, the implementation of the new requirement entails high administrative burdens and costs for the employers. Another challenge for multinational employers will be that the implementation of the EU directive varies between each member states, and multinational employers will therefore need to adjust their practices according to a local level. In conclusion, despite the challenges faced by the directive and its implementation, it will benefit in particular an estimate of 2 to 3 million workers in precarious form of employment, which include jobs that have on-call contracts or zero-hour contracts, which are extremely controversial among member states, especially in companies such as Globo or Uber Eats, for what we in Spain call riders. In essence, this directive is to become a sort of practical solution to the most harmful aspects of the gig economy. We would like to thank you very much, and please, if you have any questions, feel free to pop any comments down below. Thank you very much.